Good evening. This side Rahul Magan here is a Group Chief Executive Officer, Treasury Consulting, and also a venture capitalist. As we speak, Treasury Consulting is a multinational headquartered group based out Singapore. We are a multi-asset and multinational hedge fund. By multi-asset, I mean we actively taking positions in multiple asset classes, which includes gold and other commodities, equities and all. And by multinational, I mean to say we actively take positions in variety of countries, which includes United States, Europe, and Asia Pacific. But like I repeated many a times, and I would continue to repeat in all of my videos, that we are a proprietary hedge fund. By proprietary, I mean to say no third party, I repeat, no third party can invest capital in our funds. We do not entertain any third party capital in our fund. Today, our legal desk would be making a little comprehensive videos as where all the anti-suit injunctions, which is shortly known as ASI, or the various variants of ASI, which includes anti-enforcement injunction, anti-arbitral injunction, anti-suit injunction, and anti-arbitral injunctions are possible. Like I repeated in one of my videos, that injunction is nothing but a kind of temporary or a restraining order whereby any judicial authority, I repeat, any judicial authority, it might be a trial court, it might be a session court, it might be the first appellate court, it might be the high court, it might be the Supreme Court, or probably arbitral tribunal himself. So any judicial authority can give either a temporary or a permanent restraining order to the second party, who might be a plaintiff or might be a defendant, not to do certain activities. Like I clearly said, that there is a big difference between injunction and stay orders. However, I already clarified in detail in my earlier videos about the two big myths about injunction. Many people do not understand an exact difference between injunction and stay order. Please be note that, like I said, injunction can be granted by any judicial authority, while stay is always granted by the higher court, which means suppose the trial court is saying you are supposed to do this and you want a stay on that order. To have this stay, you will go to the higher court, because the higher courts are governed under stare decisis, which means whatever they would say would be applicable to the lower courts. So higher court will give a stay. So in short, there is a big difference between the injunction and the stay. Please do understand that there are variety of industries we have in the world, though limited, who have complicated contracting. And fortunately, I worked in two of them. Number one is definitely the investment banking. Investment banking is an industry who raises money for their clients. It could be non-convertible debentures, it could be the equity issuances, it could be initial public offers, it could be private equity, it could be venture capitalist, it could be venture debt, it might be OFS, offer for sale, it might be junk bonds, it might be non investment grade bonds, or it might be subordinate bonds. So, investment banking is an industry who raise the money for the client. And if I speak about the big investment banks of the globe, not to mention any specific name, they are dealing with large parties. Basically, in English, we have a word called conglomerates. Conglomerates include Samsung, Reliance, Amazon, Google, Apple, Microsoft, Facebook. Basically, they are the organizations who practically doing business everywhere in the world, like Amazon. Amazon recently sold their debt, right? Definitely, they must have hired somebody as an investment banker who did all the activities for Amazon. But Amazon is a conglomerate. And we need to understand that the contracting which we are doing for Amazon, it cannot be drop of a hat, which means that you cannot take this lightly. You are supposed to do the contracting which is highly immaculate, which is away from all errors, which should cover each and possible thing that comes in your mind, which should try to cover all probable disputes, pricing errors, pricing misconceptions, because you would love to maintain a cordial relationship with Amazon for a longer period of time. And this could only be possible provided the work which you did for Amazon is a blemish free work. Both Amazon and yourself should not end up in a situation whereby you both love to see each other in the court of law and wasting each other money. And of course, reputation is at stake. In this regard, the contracting is supposed to be very, very immaculate. This isn't an obligation. Please note that. This isn't an obligation. This is something which is must, because you love to maintain a cordial relationship with Amazon. Second industry is the merchant banking. You know, like Amazon sold their debt. Recently, Elon Musk, Mr. Pump and Dump, bought Twitter thanks to the court, and he arranged $44 billion for Twitter. And I got a screenshot from Bloomberg which confirmed that around 13 billion, 1 3, the 13 billion is, arranged in the form of debt from respective banks. I have the list of the bank, but there is no point of mentioning the names here. From where he accumulated the rest 31 billion, I have no idea, but I'm planning a detailed video in that regards. So whatever 13 billion Musk arranged from different banks, it might be syndicated, it might not be syndicated. But having said that, I have very limited information in this regard because the acquisitions happened just 2 days ago. And unfortunately, internet too is having a very limited information in this regard. Henceforth, comment is not possible. But one thing I'm sure, and I saw myself many times, that when a syndication act is happening, which means that 13 billion is a big money, and especially in today times when we are facing recession, big corporates are cutting jobs, the government is increasing taxes, huge losses are happening, job cuts are going on, and whatnot. All kind of mess is happening worldwide. In this, keeping this as a backdrop, arranging $13 billion, it's really a big thing. Let it be very honest. But having said that, he arranged. At what price he arranged? What is the cost? We do not know, but one thing which is definitely certain, one thing which is definitely can speak is that the contracting which the banks did with himself, his organization provided Tesla. I don't know whether any corporate guarantees provided, any personal guarantees provided, any ISDA agreements being signed, any loan agreements. There are few standard loan agreements signed or not. But contracting is supposed to be immaculate, because God knows what would happen in the near future, whether Twitter would perform, whether Twitter, may sink, probably some other, social platform, maybe LinkedIn, maybe YouTube, maybe WhatsApp, maybe Telegram. They would do some form of innovation and they would take up what Twitter is doing. So we barely have any idea in that regards. Contracting is supposed to be immaculate. Third is the information technology, because information technology like TCS, SCL, Infosys, Wipro, Amazon, Accenture, Cognizant, and many respective IT companies, they work for their clients, and they work for multinationals. Like example, I again repeat, it's an example. HCL works for Microsoft, assuming TCS is working for Amazon, probably any other company, then you are representing or you are parting your services to a multinational firm. Now that firm may or might not be, I would say, conglomerate, but today we have multinational firms. In this eventuality, the disputes are bound to happen either side, which means you are imparting your services, the person is not very happy. He feels that the pricing which you are charging, your competitor is charging a lesser price. So again, creating a hypothetical example, I repeat, it's an hypothetical example, that suppose Infosys is giving some contracting to, doing some work for Amazon, assuming, and suppose they are charging $50 per person per hour. I repeat, $50 per person per hour. And Amazon is getting a counter claim or counter offer from Genpact, and Genpact saying, we love to do this work, rather we give XYZ as a complimentary thing, and we love to do it at $45, which means $50 and compared with 45, it means 10% saving to Amazon. In this today time, 10% is not a small amount. Amazon loves to negotiate with Infosys. Just a hypothetical example. Guys, in this eventuality, the contracting play a very important role. Amazon cannot wind up the contract, provided the contract is specific that wind up can only happen under XYZ conditions. What would if this condition is not mentioned, that any counterparty reached Amazon and give any offer 5%, 10% or whatever percent discount, and Amazon take this as a claim to Infosys and say you should also do this billing? No. Suppose the contract which both parties signed do not have this as a place. In this eventuality, Genpact offer is mere an offer. Amazon needs a very concrete evidence to wind up with Infosys. I repeat, it's an example. Now, in this eventuality, there is a thing called governing law, but governing law actually having two brothers or sisters, whatever you say. One is called exclusive jurisdiction clause. I repeat, exclusive jurisdiction clause. And one is called non-exclusive jurisdiction clause. Now, exclusive jurisdiction clause means that both the parties, suppose I go with Amazon and Infosys as an example, both the parties are giving in writing that they love to go with India as a governing law, because Infosys feels that they are primarily an Indian company and they are imparting services to Amazon, and some part of the services the Indian entity of Amazon is also using. So henceforth, the neutral jurisdiction, basically the definition of the neutral jurisdiction means that which is beneficial for both. which is Amazon and Infosys as an example. So the neutral jurisdiction would be India. However, Amazon feels that no, I am a multinational, rather I am a conglomerate, I am a big client. People die to work with me. People die to quote my name as an example that my client is Amazon. In this eventuality, I want it should be English court of it should be New York court of law, which means I principally based out New York or probably any other state of US, and I want it should be the governing law. Now, contract is supposed to be very, very delicate in this regards. I don't know whether Infosys and Amazon they go with Indian court of law or they go with the New York court of law. It is an hypothetical example, but wherever they are going, they are supposed to be it's supposed to be one, which means either India or New York. Now this is called exclusive jurisdictional clause, which means all sort of disputes. I repeat, all sort of disputes which are going to happen between Amazon and Infosys. Please note the word disputes. You are supposed to mention each and every dispute in the contract. I know people must be thinking what kind of person I am and what I am talking. If you are not a legal expert, you can believe so. But please note that today, huge litigation cost, time, effort, money, everything is going on. To resolve this, please mention the even the worst kind of dispute that may happen. Even the worst kind of dispute, because this would save you. Remember that there is a flip side. I repeat, there is a flip side as far as the exclusive jurisdictional contracts are concerned. And the flip side is that if you do not mention the list of the disputes, or you not mentioned in your contract, in this eventuality, automatically non-jurisdictional clause will invoke automatically. Now, what the hell is non-jurisdictional clause? The non-jurisdictional clause means either party, suppose in this Amazon is plaintiff, assuming, and Infosys is defendant, either party, plaintiff or defendant, assuming, can take any court of law. Common sense, Amazon love to go with New York court of law and Infosys love to go with Indian court of law. In this eventuality, whosoever will take the first lead, I have already said first mover advantage doesn't mean you won the case, but still, whosoever take the first lead will definitely have a counterclaim on the second party. So if Amazon plaintiff will take the first lead, then the counterclaim would be on Infosys and vice versa. And if Amazon take the first lead, then Infosys need anti-suit injunction, which means they would request the honorable courts of India, maybe the high courts, maybe the Supreme Court himself, to go with the anti-suit injunction, stop Amazon not to have a case in New York, rather resolved in India. You know, there is something called principle of comity, which means that the courts should respect other courts also. So it's not that court cannot grant anti-suit injunction, but principle of comity means they should respect each other's fare, which means that Indian courts respect US court, US courts respect Indian court. But if there is a very strong feeling, very strong reason of injustice, being vexatious, oppressive, and there are various other TOR. TOR means test of requirements. If either side feel that there is a open violation of TOR, then generally anti-suit injunction is granted. Guys, please note very, very, very importantly that when you are signing a contract, please be very specific that you are going with exclusive jurisdictional clause or you are going with non-exclusive jurisdictional clause. I repeat, if you're going with exclusive jurisdictional contract or clause, then please be very specific. Please try and mention that I want Singaporean code, I want Indian court, I want Canadian court, I want, if possible, even mention the state, because in US you have New York, you know, your Texas, your Philadelphia, and there are so many states. And in US, sometimes law changes from state to state. Similar we have in Canada. We have Ontario, we have different places in Canada. So Ontario law is little bit slightly different. Then we have different state of law. So it would be better. I know that few people laugh on you. Few people will say, hey, it's Canada, right? Why are you mentioning Ontario? Why are you mentioning Toronto? Guys, just let them laugh. Say, we do not want any further dispute in the near term. Simple. It would be better if we mention Canadian state of law or Canada as governing law, and specifically mention that Ontario, so that the party cannot go to Toronto or probably any other state of Canada. This would be very helpful. So please do remember that exclusive jurisdictional contract clauses alongside non exclusive jurisdictional clauses are very important in the world of banking, in the world of investment banking, merchant banking, information technologies, where the contracts are very wide. Contracts have more than 400, 500, 600 pages. I personally dealt with these voluminous contracts in my life. You're supposed to be very alert, very vigilant, and cover each and everything possible. Please don't leave it to the destiny that, we will see what would happen. The probability of having a dispute is little and all. So please don't go that way out. This is Rahul Magan from Teshi Consulting Group. You knew my personal number, 9899 242 978. Thank you guys. Have a great time ahead.